law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome, everybody. Welcome to... Whoops, that's the wrong image there. Not a great start. Welcome, everybody, to the Law of Self-Defense show for October 22nd, 2020. This is our weekly news and Q&A show. It airs every Thursday at 4 p.m. Eastern Time, roughly. Sorry, I was a couple minutes late today. I had a bunch of meetings that ran a little bit long, but we are here. Hopefully everybody can hear us okay. This is the only show we do every week that is open access. You don't need to be a Law of Self-Defense member to participate. It is free. So come on in. Of course, we do this to grow the Law of Self-Defense community. Most of our weekly content is limited to Law of Self-Defense members. If you're watching this live, only if you're watching it live, folks, but if you're watching it live and you'd like to put in the comments your city and state, that helps provide me with some useful geographic context. And if you're watching on Facebook, if you could please click that share button, that's helpful. Also, that like thumbs up, that helps encourage Facebook to spread word of our show more broadly, and that's also always appreciated. For those who may be new to the Law of Self-Defense, I am attorney Andrew Branca. I'm an attorney who specializes in use of force law, meaning defense of self, defense of family, defense of others, defense of property, use of force law exclusively. I don't have a generalized criminal defense practice. I don't do DWIs. I don't do shoplifting, just use of force cases. And that's been the case for nearly 30 years now. So quite some time. In these weekly news and Q&A shows, what we do is we cover some typically events in the news that have occurred from a use of force context. And perhaps more importantly, we also answer your questions. Now, we typically have questions sent in ahead of time, either from our own Law of Self-Defense members or from the general public. Anybody can send in questions for our consideration via email to show@lawofselfdefense.com. If you don't get a chance to get it in for this week, you can get it in for next week. Also, you can ask questions live. And here's the lovely Emily with my coffee. Thank you so much, honey. Lifesaver. There we go. Sorry. Had a long night last night. Little tired today, but we'll get at it. Now I've got my coffee. It should be all good. So you can also ask questions in the comments. If you're a Law of Self-Defense member, you may be enjoying the show in the Law of Self-Defense membership dashboard. I see that's working today. Comments are coming in. Those questions, those live questions in those comments there will be prioritized. Next, we'll do any live questions that come in over Facebook as time allows. I do encourage you to mark your calendars because we do this show weekly, every Thursday, 4 p.m. Again, mark your calendars. You never have to miss it live. If you can't catch it live, we do leave the recorded replay available on the Law of Self-Defense blog, again, open access, as well as on Facebook, and typically on the Law of Self-Defense YouTube channel as well. Let's see what we have to dive into today. Make sure I do not forget anything. Okay, so I think I've got most of that stuff out of the way. Before we dive into the substance, and today's show will be question heavy. I don't think any particular news events that we haven't already covered in the blog earlier this week to address here today. So we'll be doing mostly questions that have been sent in beforehand and any that might be asked during the show itself. But before we dive into that, I do feel obliged, of course, to mention our sponsor for today's show, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members' legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. Just imagine a scenario where you've been threatened, you present your gun to deter the threat, you don't fire a shot, you don't hurt anybody. That meets all the legal conditions for a felony aggravated assault charge that you now have to justify as self-defense. And if the prosecutor decides to make you justify that at trial, you're looking at $30,000 to $50,000 in a legal retainer just for the pre-trial work, folks, not for the trial work. And if it's a self-defense case where you've actually had to shoot somebody and kill them, so you're facing a prospect of a manslaughter or a murder charge, very common to go through $100,000, $200,000 in legal expenses pre-trial, before you get to trial. So given those kinds of costs, it can be helpful to have a financial partner behind you to help you make sure you have the resources you need to fight that legal battle the way you want it fought, as if your life depended on it, because for all practical purposes, your life does depend on it. So that's what CCW Safe does for its members. Make sure they have those necessary financial resources. Now, there are several companies out there in the marketplace that offer similar services. I've looked at all of them, as you can imagine, and I found that CCW Safe is the best fit for me. I'm a member of CCW Safe. My wife, Emily, who just brought my coffee, also a member of CCW Safe. Now, whether they're the best fit for you, as they are for me, is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member, you can save 10% off your membership with them at that URL, lawofselfdefense.com/CCWSafe, by using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. What else? I should also mention, for those of you who are not Law of Self-Defense members, we do content, usually video, blog post, and audio content on our members-only podcast just about every day of the week. Most of the time, other than this show, that content is restricted to our members. To give you a sense of the kind of content we covered this week, we did a blog post, by which I mean text, video, and podcast, about a case in which a person who acted in nominal self-defense against a deadly force attack was denied the privilege of arguing self-defense as a legal justification at trial because at the time they were engaged in a marijuana purchase. Now, in most states, being engaged in a non-violent criminal activity does not automatically strip you of the privilege of self-defense, but in a few states, one of which is Georgia, which was the jurisdiction in this event, in a few states, self-defense is made conditional on not being engaged in any unlawful activity, even simply buying marijuana. So this was an illustration of that minority of states where the defender, otherwise acting in perfectly lawful self-defense because they were engaged in a marijuana purchase, was not allowed to argue self-defense at trial to justify their use of deadly defensive force, got convicted, off to prison they go. Another story we did was on a road rage event. This was in Kentucky, if I recall correctly. There was a minor traffic accident that pushed a car into the median of the highway. That car that had been pushed into the median had apparently been driving rather recklessly, according to witnesses. When he ended up in the median, he got out of his car, got into his trunk, retrieved a rifle, and walked over to the car that he thought had offended him, pointed the rifle inside the car. The guy in the car had a gun too. He had a Taurus pistol. He had the one that works. And he fired 4 rounds, killed the rifleman. Clearly, now the twist here is that the rifle actually was not capable of inflicting death or serious bodily injury because it was not only unloaded, but it also had a trigger lock on it. Does that matter for the pistol shooter's claim of self-defense? It doesn't matter. For the reasons we talk about in this case here, what's required under the law for justified use of force in self-defense is that you're responding to the reasonable appearance of a threat. It doesn't have to be an actual threat. Mistakes in self-defense are permissible so long as they are reasonable mistakes. And then today's blog post that went out this morning was on an event that happened, I believe it was in Israel a few years ago, but it was brought to our attention by one of our members who asked questions about it. It was a case in which a passenger in a car, or driver of a car rather, was attacked by another driver. The other driver got a large club out of his trunk, attacked the victim. The victim had a pistol in his car, came out of his own car with the pistol, shot the club wielder once, almost certainly lawful self-defense, shot him a second time, pretty sketchy, shot him a third time when there clearly was no longer a threat. and we explore a number of different legal defenses that our Platinum member asked whether or not any of those would apply, and we step through them in our analysis in that blog post that went out earlier this morning. One of those defenses, interestingly enough, was the defense of duress, which does not come up often in use of force cases, but I thought it sufficiently interesting that we dug through it in today's podcast. So if any of those topics are interesting to you, well, the way to get access to those is to be a Law of Self-Defense member. The good news is that Law of Self-Defense membership is extremely inexpensive. It's only about 30 cents, 33 cents a day. It's less than $10 a month to be a member of Law of Self-Defense, get access to all that content. And again, we do a blog post like that pretty much every workday. Even better, you can try out Law of Self-Defense membership for just 99 cents. That covers you for 2 weeks, gives you full access, just like any other member. And if you decide within that 2 weeks it's not for you, you can cancel. We'll give you back 200% of your money. So it's a negative risk proposition. And if you decide to stay a member, again, it's only about 33 cents a day, folks, to be a member of Law of Self-Defense. So if that's of interest to you, I would encourage you to point your browser to lawofselfdefense.com/trial. And for 99 cents, give us a shot. The one other thing I'll mention is we often in our legal analysis will talk about the 5 elements of self-defense. The reason we do that is because American self-defense law is based on 5 legal elements. The good news is there's only 5. There's not 500, there's not 50. And in further good news, these 5 elements, this framework applies in all 50 states, common to all 50 states. So once you understand how this 5 elements legal framework for self-defense law works, you can be confident that it applies in your state, no matter what state that might be. And if you don't understand these 5 elements, you can't possibly understand anything about how self-defense law is applied to real people in real use of force cases. The good news is we're more than happy to share these 5 elements with you, no cost, whatever. In fact, I'll tell you what they are right now. They are innocence, imminence, proportionality, avoidance, and reasonableness. And I would urge you to download our 5 elements of self-defense law infographic. It lists those 5 elements, provides a brief description of each, and it costs you nothing. It's just a PDF download, and you can get that at lawofselfdefense.com/elements. Again, if you don't understand these 5 elements, you simply don't actually understand self-defense law at all. So that's infographic is at lawselfdefense.com/elements. All right. I think with all that out of the way, I'll begin to jump through the questions that have come in today, came in since the last show, last week. Most of these are from our Platinum level members. So Law of Self-Defense Platinum level members get a members only Q&A form on their membership dashboard. Those are the highest priority questions we get. We'll always answer 100% of those, often on this show. But if a member asks to have their question answered privately, we do that as well. That's one of the benefits of Platinum level membership. This first question comes in from Gary in North Carolina. And he says, having had brain surgery and head injuries, my doctor says another injury to the head may have serious effects. If a person wants to fight him, and I tell them I do not want to fight, and that I have had serious injuries to the head, and that aggressor takes a swing at me, would this constitute deadly force? Deadly force may not occur. I guess he means death may not occur, but serious bodily injury may occur. In North Carolina, he says, a person has a right to prevent serious bodily injury and or death. And it ends there, but I guess essentially his question is, if I'm unusually susceptible to suffer death or serious bodily harm from a blow to the head, even when such a blow would not represent a deadly force threat to a typical healthy person without my physical liabilities, if I were unusually susceptible to suffering deadly force harm from such a blow, would that constitute a deadly force attack against which I would be privileged to use deadly defensive force? So, Gary, the answer to that is that the legal analysis is always the same in terms of when are you privileged to use deadly defensive force. The answer is going to be you're privileged to use deadly defensive force when you're defending as an innocent party against an unlawful imminent threat of deadly force harm. Now, deadly force harm includes not just force readily capable of causing death, but also force readily capable of causing serious bodily injury. So You don't have to be facing literal death before you can use deadly defensive force. You have to be facing death or serious bodily injury. Certainly, severe head trauma would constitute serious bodily injury. And if you are unusually susceptible to serious head trauma, and this could be because of, as in your case, brain surgery and head injuries, it could be because the victim of the attack is on blood thinners, it could be for any variety of reasons. If the nature of the attack in your circumstances, based on your physical infirmities, is one that is likely to cause death or serious bodily injury to you, it constitutes a deadly force attack, even if that identical attack inflicted on a healthy person would not be likely to inflict death or serious bodily injury. So normally, a thrown punch is deemed by the courts to be non-deadly force, absent some aggravating factors. But if you're unusually susceptible to death or serious bodily injury from that thrown punch becomes a deadly force attack for you. Excuse me. Now, Gary mentions in his hypothetical, a person wants to fight, and I tell them I don't want to fight, and then I have serious head injuries, or have had serious head injuries. You don't have to tell them anything. I mean, it doesn't hurt to tell them. You might want to tell them, but it's not necessary. They don't need to know that their use of force threatens you with death or serious bodily injury. They might believe it's just a purely non-deadly force punch that they're throwing at you. What matters is not what's in their head. What matters is what you know to be the case. Excuse me. If you know that punch is likely to cause you death or serious bodily injury, it doesn't matter whether they know that or not. That's not what's important. What's important is what the threat actually is, not whether or not they know it to be the case. So what they know about it is simply irrelevant. And of course, you're not required to wait until you're actually struck, because the law of self-defense, not just in North Carolina, but everywhere, as you note, as Geary notes, gives you a right to prevent serious bodily injury or death. That's really the element of imminence. You're allowed to defend yourself not just against an attack that's actually in progress, blows are raining down upon you. You're allowed to defend yourself against an attack that's immediately about to happen. So, strictly speaking, you don't have to have suffered a scratch before you're allowed to use force, and perhaps even deadly force, depending on the circumstances, in self-defense. You're allowed, again, to defend yourself against the imminent attack that you're facing. All right, well, Geary actually sent in the next question too, but before we jump into his next question, I see some questions are coming in. Hey, Will Parker. Will Parker just commented on Facebook. He's a self-defense firearms instructor up in Montana. He's almost in Canada, but not quite. Kalispell, Montana. Very good instructor, very good shooter, graduate of our Law of Self-Defense instructor program. If you're up in that neck of the woods, or if you find that Will Parker's teaching in your area as a travel instructor, strongly encourage you to take a look at what Will has to offer. He does great work, has hosted me many times up at his facility. I see questions are coming in on Facebook. I will wait to answer those until we get through our Platinum member questions. I expect we will have time to address most or all of the Facebook questions. So please don't hesitate to put them in to the comments. I'll get to them as best I can, but closer to the second half of the show. So Gary's second question here, again, Gary from North Carolina, a Law of Self-Defense Platinum level member, writes, quote, "Can I shoot a person with 3 to 6 rounds fast on the initial attack? I shoot fast and do not double tap and then assess the situation. The shots are fast and consecutive. How do you determine excessive force in this situation? I don't know of any cases that have determined the speed of making multiple shots." Close quote. It's a great question, Gary. And the answer is really whether or not the number of shots fired were reasonable under the circumstances or constitute excessive force is always going to be a judgment call that's ultimately made by other people. Of course, you have your own assessment of whether or not that force was reasonable. And strictly speaking, what the law says is you're allowed to continue using force as long as you continue to face an imminent threat. If it requires 3 shots to neutralize that threat, you can fire 3 shots. If it requires 6, you can fire 6. If it requires 9, you can fire 9. In theory, if it requires 100, you can fire 100. So as long as there's an imminent threat, you're allowed to continue to use defensive force. The problem is, of course, is the more shots that are fired, the less it looks reasonable. Remember, the people who are judging your conduct, ultimately jurors, are not going to know anything about guns or split times on shots or how ineffective pistol rounds are in stopping someone or how terminal ballistics can vary between a normal-sized person and a very obese person, for example, that may be attacking you. There's a lot of variables here. And the more ambiguous the situation gets, including things like a high number of shots fired, the less it looks like self-defense. And by the way, the prosecutor isn't going to know any of these things either. But he does know that we're accustomed from TV and the movies to see someone shot once or twice and they completely fall over, get blown through a window, whatever the case might be. So when he sees someone shot 6 times, it begins to look less like self-defense to him. Perhaps in good faith, he actually even believes that, and that's the narrative he's going to try to sell the jury. So it's better for the defender if they can neutralize the threat with the fewest number of necessary rounds. The fewer rounds you fire, the better the self-defense narrative is going to look. Now, keep in mind, I do self-defense law, okay, not tactics. But nevertheless, I will be the first to tell you that winning the fight is the priority. You have to do what you need to do to survive the fight. Otherwise, everything else becomes less pressing. If it takes 6 rounds to survive the fight, well, then that's what you have to do. The answer is not fire 5 rounds and die in the fight. The answer is to use as many rounds as you need to. Having said that, to the extent you can keep the round count down, it's better for your narrative. So what are ways you can do that? Well, frankly, the biggest one is shot placement. Are you actually proficient with that firearm? If you miss a lot or you get a lot of ancillary hits on an attacker, you're going to end up firing a lot more shots, and that weakens the strength of your self-defense narrative, having fired those many shots. If you can get 1, 2, 3 shots center mass that effectively neutralize the target, well-aimed, well-placed, effective hits, even a pistol can do an effective job if the shots are placed well. They tend to be ineffective when the shot placement is marginal. Rifles in that context tend to be much more effective. So if you can keep the count down, better for your self-defense narrative. The law allows you to fire as many shots as necessary, but the more shots you fire, the harder a sell it is that it was in fact necessary. And again, the people evaluating this don't know anything about guns or tactics or terminal ballistics or anything. Now, I will say this, unless the round count is really egregious, unless it's 10, 12, 15 rounds, and I know some of you are thinking, well, the police sometimes do that and blah, 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 it's okay for them. Forget it, folks. Unless you're a police officer acting in the capacity of a police officer, those examples don't apply to you, no matter how much we might wish they would. So forget it. Just set that aside. Unless the round count is egregious, people do not tend to get into trouble because they, for example, fired 4 shots, 5 shots, even 6 shots very quickly, 0.2 of a second split times. And the prosecution goes, well, I'll tell you what, you fired 6 rounds in a second and a half, and I will give you the first 5. The first 5, totally privileged, lawful self-defense, but that 6th round, that's the one you're going to prison for the rest of your life on. That's not how these scenarios tend to play out. Where people tend to get in trouble in terms of too many rounds, excessive force, unreasonable force in terms of round count, is not so much the number of rounds itself, but the manner, the cadence in which they're fired. People tend to get into trouble when they fire a series of rounds, one initial burst of fire, and then there's a pause in the action. Often it's several seconds, 3, 4, 5, 6 seconds, and then they fire again. The difficulty there is what's happened in the pause is, in fact, the threat was neutralized. What was an imminent threat that you had fired at is no longer an imminent threat. And during that pause, you should have realized that that was the case, that in fact your initial use of force had been sufficient, you've neutralized the threat, but instead you come back and you fire yet another round. In that circumstance, that second round, or rounds, depending on the circumstances, could well not be privileged lawful self-defense even when the first burst of fire was. And the reason is, well, because of those 5 elements of self-defense. The first rounds were justified because you were, when you fired those, facing an unlawful imminent threat of deadly force harm. But after that pause, that harm no longer existed. The threat of harm no longer existed. So when you fired shots after the pause, those shots were not being fired while you were facing an unlawful imminent threat of deadly force harm. Therefore, those shots, the second set of shots, cannot be justified as lawful self-defense. Another question from a Platinum member, David M. from Ohio. He's got a question about the Platinum Protection Program that we have here at Lawful Self-Defense. This is a program you can sign up for. It's the only way to guarantee that I'm available for your legal defense. It also provides you with platinum level access to all of our content. The truth is, folks, that I'm extremely busy, work almost 7 days a week, have really more casework than I care to have, to tell you the truth. So it's extremely difficult to get me to be available for a case. Most of the time these days, I have to say no. I have to decline to take casework. And that's unfortunate for the people involved in those cases, but I simply don't have the bandwidth. And I can't simply abandon all my other commitments for a prospective client I've never heard of before who calls my office and is in desperate need of help. I have to honor those other commitments. The only exception to that is if you are a Platinum Protection Program member, because then you've made a commitment to me in turn prior. So then I am in a position where I can drop those other commitments because essentially you come first in priority. The only way you can guarantee I'm available for your legal defense is to be a Platinum Protection Program member. Now, sometimes people like David here seem to confuse what we offer in the Platinum Protection Program with what other companies like our sponsor, CCW Safe or USCCA or Armed Citizen Legal Defense Fund, the so-called, mistakenly called self-defense insurance programs out there offer. We don't offer the same thing they offer. They're different. Those organizations will purport to pay your legal defenses generally. So they pay for your lawyer, they pay for experts, they pay for various things. It all varies by program. You'll have to look at those programs for their details. But in essence, their commitment is to pay legal expenses generally. Our Platinum Protection Program at Law Self-Defense covers only me. So you don't have to pay for me under the program. That's included in the monthly fee you pay to be a Platinum Protection Program member. But that's the only fee it pays, is my legal expense. So normally, my current rate for a consultation on a case when I'm available to take a case, which isn't very often, is $10,000. So that's what's covered. Our Platinum Protection Program members, when they need my legal consultation for a use of force event, they don't pay anything. It's completely covered. But if they have other expenses, those are not covered by the Platinum Protection Program. And I don't provide an attorney for anybody. You're getting my legal services. That's it. Now, I can recommend attorneys that I've worked with, probably in your jurisdiction, people I know are good, and I'm happy to do that for our Platinum Protection Program members that are involved in a use of force event, are having difficulty finding good legal representation, and that attorney becomes lead counsel on your case, and they become my client for my legal consult on your case. But I don't provide an attorney in the sense of paying for that attorney for you. That's your responsibility. We did have a great question come in from Platinum Protection Program member Tammy, and it involved questions about the legal defense of duress, and she also linked a video to provide context around her question. But the question was so good, we actually answered it yesterday in a full-blown blog post. If you're interested in checking that out, you will need to be a Law of Self-Defense member. But it's the blog post with this featured image, turning self-defense into an unlawful killing, or does the legal defense of duress excuse that use of force? So, Tammy, if you're listening and you were looking to get your question answered here, instead of spending just a minute or two on it here, we spent a good 20 minutes answering your question in yesterday's blog post. And of course, as a Platinum Protection Program member, you have open access to that blog post. It's this morning's blog post, not yesterday's. This morning it went out. I wrote it yesterday, but we put it live this morning. We got another question from a Platinum Protection member in Minnesota. I don't think he provided his name with the question, which is fine. It's fine to be anonymous. And he asks, explain self-defense immunity. Now, self-defense immunity is often misunderstood, and that's largely the result of the grossly imperfect and incorrect way that the media, and unfortunately, too many people in the legal profession, describe self-defense immunity and how they conflate it with completely distinct legal doctrines. Like stand your ground, for example. And part of this is the fault of the state of Florida. So years ago, the state of Florida, I believe it was 2005, adopted stand your ground. So before, Florida was a duty to retreat state. You had a legal duty to retreat if safely possible before you could use force in self-defense. If you did not take advantage of that safe avenue of retreat, you were not privileged to claim self-defense to justify your use of force. Florida adopted stand your ground, which removed that otherwise existing legal duty to retreat. Now you could qualify for self-defense without having to try to take advantage of a safe avenue of retreat. Essentially, of those 5 elements of self-defense, innocence, imminence, proportionality, avoidance, and reasonableness, stand your ground takes the element of avoidance off the table, assuming you meet the conditions to qualify for stand your ground under Florida law. The same time that Florida, one way to think about stand your ground is it redefines the scope of self-defense. So self-defense has up to 5 elements. One of those 5 elements is the element of avoidance. So for your conduct, your use of force to qualify as self-defense, it has to meet those 5 conditions. If it fails to meet any one of those conditions, whatever it was not lawful self-defense. What Florida did with stand your ground is remove one of those 5 conditions. Now there's only 4 conditions. That means there's a broader scope of conduct that can qualify as lawful self-defense than was the case previously, because you have fewer conditions you need to meet. It redefined, it broadened the scope of what qualified as lawful self-defense, the adoption of stand your ground, by removing, in effect, that element of avoidance, one of the 5 elements of self-defense. At the same time that Florida adopted stand your ground, simultaneously, but in a completely different statute, it also adopted what's called self-defense immunity. And self-defense immunity has nothing to do with stand your ground, completely independent. What self-defense immunity says is it has nothing to do with the definition of self-defense, what qualifies as self-defense. Nothing. Remember, stand your ground redefined self-defense. Self-defense immunity has nothing to do with the definition of self-defense. Self-defense immunity merely says if your conduct meets the conditions of self-defense, however those conditions may be defined elsewhere, because they're not defined by self-defense immunity. They're defined in other places, other statutes. Self-defense immunity says if your conduct, your use of force, meets the conditions of self-defense as they're defined elsewhere, then you are immune from criminal prosecution, immune from civil suit. Which of those, and whether it's both of those, depends on the state. In Florida, it's both. So under Florida law, if you meet the conditions of self-defense as defined under Florida law, you can be immune from criminal prosecution and immune from civil suit. But the definition of self-defense could change again in Florida. They could remove an element. They could get rid of stand your ground and reincorporate avoidance as an element of self-defense. So the definition of self-defense could change. But that doesn't change self-defense immunity. Self-defense immunity merely says, however self-defense may be defined, if you qualify, you're privileged to be immune from prosecution, immune from civil suit. 2 different statutes, 2 completely different legal doctrines. Unfortunately, because Florida adopted both of them at the same time, it's very common to see the media and even legal professionals refer to both of those legal doctrines, completely distinct legal doctrines, refer to both of them as stand your ground. Only one of them, stand your ground. Stand your ground merely relieves you of an otherwise existing duty to retreat. Self-defense immunity has nothing to do with stand your ground per se. And by using the same phrase to describe these 2 completely distinct legal doctrines, as you might imagine, it only causes confusion. Now, I already kind of described what self-defense immunity does. If your conduct meets the conditions for self-defense, you're immune from criminal prosecution and civil suit. But there's a better conceptual way of understanding self-defense immunity, and that is that how I think of it is really as a much improved, much more efficient less cost, less time way of establishing self-defense as a matter of law. And when I say less costly, less time consuming, I mean compared to the normal way of establishing self-defense in an absolute way, which is to go to trial and have a jury return a verdict. I mentioned at the start when I talked about CCW Safe, our sponsor, that a killing trial, a manslaughter or murder trial, can easily cost a couple $100,000 before the trial itself. It can take years to get to and through a murder trial in terms of the pre-trial effort and then the trial itself. And then at the end, maybe you're convicted, but maybe you're acquitted on the basis of self-defense. And then, we discovered at the cost of hundreds of thousands of dollars and years of our life that, in fact, it was self-defense all along, just like the defendant claimed. It's a way to get to a finding of self-defense, but it's a very costly and time-consuming way to do it. What self-defense immunity does is provide an alternative path to get to that same conclusion. Was it lawful self-defense? And if it was, you're without criminal liability, just as if you'd been acquitted at trial. And the way it does that is when you apply for, your lawyer would file a motion for a hearing in front of usually the trial court judge. When you apply for self-defense immunity, you're doing it pre-trial. Now, it doesn't mean it's free. It still costs a few $1,000s to have a pre-trial hearing. Maybe several thousands of dollars to have a pretrial hearing, depending on how complex it is and whether you bring expert witnesses in and so forth. But it's far less than the hundreds of thousands of dollars you can easily spend on a murder trial, and you can have it done in a matter of weeks instead of a matter of years. It all happens pretrial, so it happens before you incur the time and cost of the trial itself. And typically how it works, and the Florida standard's a little bit different than this, but typically how it works is if the defendant can convince the judge by a preponderance, a majority of the evidence, that his use of force qualifies as self-defense, the judge can grant the defendant immunity from prosecution and civil suit, and there's no need for a trial. We've made an absolute determination of self-defense pre-trial at the cost of a few $1,000s in a few weeks instead of hundreds of thousands of dollars in years. Now, strictly speaking, in Florida, they've changed the legal threshold. Now, when you file a motion for self-defense immunity in Florida, the burden's on the prosecution to disprove your claim of self-defense by clear and convincing evidence. I don't want to get into the details of all that, except that it's a more favorable legal standard for the person applying for immunity than if they had to prove self-defense by a preponderance of the evidence. Let's see what else we have here. So that's the best way to think about self-defense immunity, as a more efficient, more timely, less costly way of determining self-defense as an alternative to the tremendous cost and time of going to trial itself, by being able to seek self-defense immunity in a pre-trial hearing. Okay, folks, so those are all the questions I had sent in from Platinum members this week. Let me start going through questions that have come in while we've been on the show live. First, of course, I'll go through the comments on our Law Self-Defense members dashboard. They get priority. Alex asks, can you talk about how self-defense applies to potential injuries to innocent third parties? A la Breonna Taylor. Had she been innocent? Well, for our purposes, let's assume she was entirely innocent, an innocent bystander. A attacks B, B tries to defend, unintentionally shoots C. How is B treated by the law? So you're attacked by some guy, let's say he's wielding a machete, he's coming right at you, he's 10 feet away, not a complicated tactical or legal analysis there. You draw your pistol, you shoot that guy, or at least you shoot at that guy. Let's imagine you do, in fact, hit him and neutralize that threat, but one of your rounds misses or over-penetrates and continues downrange, strikes an entirely innocent bystander, someone you didn't even know was there. Has nothing to do with the attack upon you, certainly bears no fault in the attack upon you. Again, an entirely innocent bystander. What is your legal liability there? Well, assuming that your use of defensive force was reasonable and non-reckless, what applies there is a doctrine called transferred intent. As long as your intent in firing the shot at your genuine attacker was a good intent, in other words, your use of that force was lawful self-defense, that good intent follows the bullet and transfers to that innocent bystander. So if you had no criminal liability for firing the round at the attacker, you don't have any criminal liability. Really, it would also apply to civil liability for the round that hits the innocent bystander. It's just bad luck. It's essentially a form of accident. Now, that good transferred intent doctrine would not apply if your use of force in self-defense was in some way reckless, negligent. Say, for example, the guy is coming at you with the machete, and in fear, you cover your eyes with one hand and just do a magazine dump with the other hand. Well, I think most of us would agree that that's not a non-reckless way. That's not a responsible way of firing a gun in self-defense. If your conduct, if your use of force was reckless in nature, then you don't get the benefit of transferred intent. Or to put it another way, your intent was not a good intent. It was not an innocent intent. It was not a responsible intent. It was a reckless intent. And if you kill someone recklessly, that's just involuntary manslaughter. So you'd be on the hook for involuntary manslaughter. You didn't intend to kill the innocent bystander. You had no murderous intent towards them. But your conduct was inherently reckless. You disregarded the risk of death that you were creating towards innocent people, and a death actually resulted. That's the classic definition of involuntary manslaughter. It's much akin to a drunk driver who drives over a pedestrian in a crosswalk because they're intoxicated. They didn't mean to kill the pedestrian. That wasn't their intent or purpose. But by driving intoxicated, they created a high risk of death to an innocent person. That's the definition of recklessness. They disregarded that risk. A death resulted. It's involuntary manslaughter. So in the Breonna Taylor case, we have the cops serving the warrant. The warrant was good. They didn't have to knock, but witnesses say they did knock, kicked the door down. The boyfriend in the house says he thought they were home invaders. Let's assume that's true. So the cops kick the door down. He doesn't know they're cops. He thinks they're home invaders. He shoots at the cops. Arguably, he's acting perfectly lawfully, defending his home against what he reasonably perceives, we'll assume, for our purposes of discussion, were home invaders. The cops get fired on. Well, they're allowed to defend themselves, so they return fire at the boyfriend. That's also a lawful use of force. So we have a situation where we're about to have an awful outcome, but in fact, nothing criminal has happened. The boyfriend firing his shot was lawful, we're assuming. The cops returning fire, also lawful. Breonna Taylor gets struck by one of the officer's rounds multiple times, I guess. But in any case, she's mortally wounded and she dies. So long as that officer's firing of the rounds was non-reckless, in other words, it resembles an attempt to neutralize the attack upon them, there's no criminal liability there. The officer didn't do anything criminal. It's just a terrible accident, a tragedy. An innocent bystander, in this case Breonna Taylor, ended up dead as a result of this gunfight, but no criminal liability attaches. Now, the one officer who was charged in that case was charged specifically on the grounds that his firing of rounds was reckless. He fired some rounds that went into some other apartment. Now, I don't know whether they were reckless or not because I haven't seen the evidence, but that's the argument that's being made. And of course, as we already know, based on our discussion so far, it's a reasonable argument. If his use of defensive force was reckless, say he closed his eyes and did a magazine dump, now he didn't actually hit anybody, but the charge is reckless endangerment, I guess. If it was reckless, then it can't be justified as a lawful use of force because it wasn't reasonable. And reasonableness is, of course, one of the elements of self-defense. Let's see. Oh, the question of self-defense immunity, it turns out, came from Pete C. He's one of our platinum members. He commented here. Ortiz asks, implications of the third-degree murder charge against Chauvin being dropped in the Floyd case. So this is news that just came out today. Chauvin, this is one of the officers in the George Floyd case. He was the officer kneeling on Floyd's neck. Had a number of charges, I believe, basically first-degree murder, felony murder, third-degree murder, which is, if I recall correctly, I didn't review this, so if I'm mistaken, I'll correct later. I believe it's involuntary manslaughter, reckless killing. And a couple of the other cops who've been charged in the case all had a hearing in front of the judge today, where their lawyers were seeking to get all the charges dismissed for lack of probable cause. In the case, the other two cops got nothing dismissed, I don't believe. Chauvin did get one of the charges against him dismissed, and it's that third-degree murder charge. Unfortunately, and the good news is the judge appears to have written a fairly extensive opinion explaining why he refused to dismiss most of the charges, but did dismiss that one. Unfortunately, I haven't had a chance to read his decision yet. And I don't want to comment in detail on the decision without having read it. But I will read it today or tomorrow. If I don't comment on it by tomorrow, I'll certainly do something over the weekend and provide a more detailed analysis and a dedicated blog post for our members just on that decision in the Chauvin case, rather than try to address it in just a minute or two in the show today. So sorry, Ortiz, but I'm going to delay a substantive response to your question until I have an opportunity to give it the attention that it genuinely deserves. Okay, that looks like all the questions from our members in the Law of Self-Defense members dashboard. Again, if you'd like to try out membership, folks, it's really inexpensive. It's 99 cents for 2 weeks. If you decide you don't like it in that 2-week period, you cancel, we'll give you 200% of your money back. It's a zero risk opportunity. If you do decide to stay a member, it's still cheap. It's only about 33 cents a day, less than $10 a month, and you get access to all our content, hours and hours and hours of law, self-defense, video, text, podcast, self-defense law, insight, education, expertise that we produce virtually every day of the week. So dozens of hours every month of this kind of content. If you're interested in that, you can try out lawofselfdefense.com/trial. Okay, let's look at the questions now that have come in on Facebook. Lots of good friends on Facebook. Hey, Art Jocelyn is a graduate also of our Law of Self-Defense Instructor Program. And currently, after he had that experience and we had dinner, Art decided to go to law school. So he's actually currently in law school, unless he's graduated. Sorry, Art, I can't remember now if you actually finished the process already. I lose track of time. But Art's, it doesn't happen with great frequency, but we have a number of members of the law self-defense community who end up going to law school after experiencing membership. Sean Sorrentino, another friend of law self-defense. Thanks, Sean. He also mentions the charge being dropped, the third-degree murder charge being dropped against Chauvin. I'll address that within the next few days, Sean, after I've had a chance to read the decision. Paul Brochure asks on Facebook, does a complicated defense if you are armed in violation of your employer's directions? What if your employer is a government agency? Census folks plotted lots of dangerous places that we had to enumerate, but stressed that we were not allowed to carry arms. So what are the implications of carrying arms contrary to your employer's direction? I don't want to deal with government employees specifically, because that begins to create some complexity around the issue. But you're a normal civilian employee. Your boss says you're not allowed to carry a gun on company property or while engaged in company services, and you do it anyway. What can happen to you legally if you're involved in a use of force event and it's discovered that you have that gun contrary to your employee's instructions? Well, it doesn't fundamentally harm your core claim of self-defense. Not carrying contrary to employee direction is not an element of a self-defense claim. And it's not a violation of the law. Now, again, it can get a little complex depending on your state. If the property is posted against guns and that has legal criminal effect in your state, then you could arguably be committing a crime while you're also violating your employee's direction. But those are really two different things. One is a workplace instruction, does not have criminal legal effect. It's possible the posting could have criminal legal effect. In some states, postings do. In some states, they don't. Our expertise is not really gun law, so I'll defer you to whatever your state level expert is on gun law in your jurisdiction. But if you're carrying contrary simply to employing instructions, it doesn't lose you self-defense at all. Really has nothing to do with it. Of course, you could lose your job. In fact, I would expect you to lose your job. Your employer sets the terms for employment. You violate the terms, you should expect to be terminated, not have a job anymore. Now, if you carrying the gun does have some potential criminal legal effect, in most states, it still won't undermine your claim of self-defense at its core. Just like I discussed earlier when I talked about the gentleman who was involved in a use of force event while buying marijuana, most states don't care in the context of self-defense if when you defended yourself, you happen to be engaged in some criminal activity, so long as the criminal activity is of a non-violent nature that doesn't make you the aggressor in the fight, for example. If you're the aggressor in the fight, you lose self-defense because you lose the element of innocence. But they don't care about criminality generally. So if you're speeding or selling drugs, or that normally does not influence your claim of self-defense. There are a few states, one of them is Georgia. If the criminal activity is a felony level, then you lose the privilege of self-defense because you've lost innocence under Georgia law because you were engaged in felony conduct at the time you used force. In the case I cite with the marijuana, purchasing marijuana, apparently of any amount in Georgia, qualifies as a felony. So if you have to defend yourself while you're in the progress of purchasing marijuana, you don't have a privilege of self-defense. It's maybe something to keep in mind. However, it's also important to keep in mind that even where being engaged in some unlawful activity might not lose you your core claim of self-defense, it could influence the definition of self-defense that will be applied to you. So you don't lose self-defense per se, for example, but if you're in a stand your ground state, especially the roughly 17 states that are stand your ground by statute. So the legislature passed a statute that says there's no duty to retreat. Typically when they do that, they impose conditions on stand your ground. You have to meet those conditions to qualify for stand your ground. If you don't meet the conditions, it's not that you lose self-defense per se, but you may lose the benefits of stand your ground. In other words, you may reacquire that legal duty to retreat that existed before the legislature passed the stand your ground statute because you don't meet the conditions for stand your ground. And a very common condition of stand your ground in the statutory stand your ground states is that you not be engaged in unlawful activity. So if you work for somebody and they post their property that no guns are allowed, and that posting has criminal effect, now we have two bars to having a gun. The workplace directive, which doesn't have criminal effect, and the posting, which we're assuming here does have criminal effect. Well, if it has criminal effect, then you're committing a crime by having the gun. If your state stand your ground privilege is conditioned on not being engaged in criminal activity, and you lose stand your ground. It doesn't mean you lose self-defense, but now you've reacquired that legal duty to retreat, if safely possible, before you can defend yourself, because you don't qualify for being relieved of that duty under your state's stand your ground law. Dominic says he's a CCW instructor, would like to teach the legal portion of the class myself. What can I do to limit legal liability on my behalf, like additional education? I'm sorry, Dominic, that's really beyond the scope of what we do here. I assume you mean you're an NRA instructor teaching something like their personal protection course, which I haven't looked at it in a while, but the last time I looked, it had a legal portion that they say needs to be taught by a lawyer or a police officer or something similar. Frankly, I think it's a ridiculous condition. I know plenty of self-defense instructors who know far more about self-defense law than most lawyers. Most lawyers don't know very much about self-defense law at all. You're not magically gifted with self-defense law knowledge because you went to law school, folks. In my 3 years of law school, we spent maybe 3 years in self-defense law. You can just imagine if someone's a real estate lawyer, for example, what do they know about self-defense law that a firearms instructor couldn't learn? I mean, it's ridiculous. And frankly, the situation's much the same with many police officers. So I think it's a ridiculous requirement of the NRA. There should be some qualification for teaching the legal portion, but it should be some kind of training with an examination component that everyone should have to pass, whether they're a lawyer, a cop, or anybody else. Instead, they just presume that if someone's a lawyer or a cop, they must know the self-defense law stuff. It's just not true. So I think it's a terrible condition. It's a mistake that the NRA imposes for those courses. But commenting on how you can reduce your liability for that context is really beyond the scope of what we do here at Law of Self-Defense. I can tell you, if you really want to know self-defense law at a very in-depth level, you might consider our Law of Self-Defense instructor program. Currently, through this year, it does not license people to teach law of self-defense content. We are changing that next year. We will begin certifying law of self-defense instructors next year. But currently, our law of self-defense instructor program is basically designed as what a law school level semester-long seminar on self-defense law would look like if any law school taught this stuff at that level, which to my knowledge, none of them do. It's the most in-depth instruction available anywhere, to my knowledge, including law schools, that you can get on self-defense law. If that's of interest to you, you can point your browser to lawofselfdefense.com/instructor to learn more about that. Alexander says, you convinced me to sign up for CCW Safe. Honestly, folks, I think it's head and shoulders above, head and shoulders may be too strong a word. It certainly best fits my circumstances. Another organization to consider that has great merit is Armed Citizen Legal Defense Network. It's what they offer is different in important ways, so it's important you look at the details and understand what it is you're getting. The other major competitor is USCCA, which I simply can't currently recommend at all, although I used to. I used to work with them on their legal advisory board. Because USCCA is getting sued in federal court for not covering a member's legal expenses, and they won't explain why, except to say we have no obligation to pay, which is fine, I guess. But if that's their position, I certainly can't recommend other people to sign up for their, legal defense services program if they're only going to cover you if they feel like it. So until they provide a reasonable explanation for why they're not covering those members' expenses, I simply can't recommend USCCA currently. Art, I mentioned Art earlier. He's going to law school after some experience with law of self-defense, particularly our self-defense program. He says in a 15-week criminal law class in law school, he had about 30 minutes of self-defense law. Well, that's about 27 minutes more than I had back in 1988. So I'm glad to see they're doing more. But folks, all of you got twice that much exposure in today's show as Art got in his criminal defense law class. So keep that in mind. All right, folks, I think those are all the questions, and we're right about at the top of the hour. I like to respect everybody's time, including, of course, my own. So I just want to remind all of you, we do this show live every week, Thursdays, 4 p.m. You don't need to be a member. It's our only open access content. You can catch it here on Facebook, on YouTube, and of course, our members of the Law of Self-Defense membership page. I encourage you to mark your calendars, Thursdays, 4 p.m. Eastern Time, so you never miss a show. If you'd like to send questions in for our consideration, you can email those to show@lawofselfdefense.com. And I guess besides that, I'll just remind all of you that if you carry a gun so that you're hard to kill, and that's why I carry a gun, have my entire adult life. If you carry a gun so you're hard to kill, you also owe it to yourself to make sure you know the law so that you're hard to convict. All right, folks, until next time, I'm attorney Andrew Branca with Law of Self-Defense. Stay safe.